I'm Lisa Pepper. I'm a partner in Osborne Solicitors in Camden. I specialise in family law. If you are facing the prospect of divorce, not only is it a very traumatic time, but you're also thinking about the possibility of instructing a solicitor, the involvement of the court, the legal jargon. It's all very daunting. I'm here today to talk to you about divorce procedure and explain some of the terms used and the stages that you go through to obtain a divorce. If you do then have to go and see a solicitor, you will know some of the things that you will be asked in advance and have had time to think about your answers. The first and most important thing that you need to know is that you don't need to go to court to obtain a divorce, and neither in fact does your solicitor. The piece of paper that you need to prove in future that you are no longer married is called the decree absolute, and in order to obtain that document from the court, you don't need to attend any court hearings whatsoever. You may, however, need to go to court if you and your spouse cannot agree matters concerning a financial settlement on divorce and also matters concerning the children. That is, however, only if you cannot reach agreement with the assistance of a solicitor, perhaps a collaborative lawyer like myself or a mediator. I'm not going to talk to you today about financial arrangements on divorce or children. I'm just going to focus on the basics of divorce procedure. To start things off, one of you needs to ask a solicitor to draft a divorce petition. The person who starts the procedure at court is called the petitioner, and the person who receives the petition is called the respondent. It's much better to agree who is the petitioner and who is going to be the respondent in advance. You can't always do that, but it is preferable, and I'll talk to you a little later about cooperation. The solicitor will draft the divorce petition, and there are certain things in the petition that must always be stated. First, the ground for divorce. There's only one ground for divorce in England and Wales. That's the irretrievable breakdown of the marriage, so that will always be stated. Then, there are one of 5 facts that must be stated in the petition. First, you can use adultery. Next, you could use 2 years separation with consent. Third, behaviour. Fourth, desertion. Fifth, 5 years separation. You must choose one of these to state in the petition if you are the petitioner. The most commonly used facts are 2 years separation with consent, adultery, or unreasonable behaviour. With 2 years separation with consent, you obviously have to wait 2 years. Not everybody wants to do that. Also, you have to have the consent of the respondent. If you are in any doubt as to whether the respondent will cooperate with the divorce, I would not recommend to a client that that fact is cited. It is the closest, however, one can get to no-fault divorce in terms of what the petition says. 2 years separation with consent is neutral, and therefore many people use that. As an alternative, the fact of adultery can be stated in some cases. Bear in mind, this always has to be the adultery of the respondent, not the petitioner. One would only recommend stating the fact of adultery if the respondent will admit the adultery in the acknowledgement of service form, which is a form that they are sent by the court with the petition. If the respondent spouse is not willing to admit the adultery, I would not recommend to my clients that they state that fact in the petition. If you don't want to wait 2 years and nobody's committed adultery, or you don't want to state that fact in the petition, the third most common fact cited is unreasonable behaviour. That is quite surprising, given that there is a general idea that there's no fault divorce, when in fact, in the end, you might end up having to cite the other person's unreasonable behaviour. That's particularly difficult when perhaps you have simply grown apart and there is no blame on either side as to why the marriage has come to an end. Nonetheless, it might be the fact that you have to cite. If you decide to use the fact of unreasonable behaviour, the petition must state several examples of the respondent's behaviour, and that behaviour needs to be so bad as to persuade the court that subjectively for the petitioner, it led the petitioner to decide that the marriage was at an end. What it is a good idea to try to do is to make the particulars of the behaviour as mild as possible, but still sufficiently high to get them past the court. And a solicitor will usually send the draft petition to the respondent or their solicitor to check that they are comfortable with the behaviour particulars stated and invite any suggested amendments if there is something that the respondent is particularly uncomfortable about. That will hopefully secure their cooperation and the divorce can proceed smoothly from the outset. The petition will also include a statement about the costs of the suit. The costs of the suit are the discrete costs of getting the petitioner to decree absolute, the final decree on divorce. They don't include the wider costs of helping the petitioner reach a financial settlement on divorce or any matters concerning the children. The petition will state whether the petitioner is asking the court to order that the respondent pays the costs of the suit, or whether it is perhaps 50-50, or if it is silent on the costs of the suit, the petitioner will be bearing their own costs with no assistance from the respondent. That is something for you to consider, and you will need to give your solicitor instructions about what you want the petition to state on the costs of the suit. So that covers some of the basics about what a divorce petition must contain. Another important document that must be completed is the Statement of Arrangements for Children. This is a document just setting out where the children go to school, where they live, if they will see the other spouse after the divorce, etc. And your solicitor can help you complete that. Those documents are then sent to the court, and the court then issues the petition, which means that it will bear the court seal and then it will be sent out either to the respondent or their solicitor directly, or back to the petitioner's solicitor first. The petition and the Statement of Arrangements will also be accompanied by an Acknowledgement of Service form. This form is sent to the respondent and requires his or her completion. It is an important form. If the fact cited is 2 years separation with consent, then the respondent's signature to the form and agreement to the divorce is crucial. If the fact cited in the petition is adultery, the respondent admits the adultery in the acknowledgement form and signs it. Completing the Acknowledgement of Service form and returning it to the court is the next stage in the divorce, and it is the only action required by the respondent or his or her solicitor in the divorce process. Once that has been completed, the next stage is back to the petitioner. They must complete, with their solicitor's assistance, an affidavit swearing that the contents of the petition are true. That is sent to the court with an application for decree nisi. The pronouncement of decree nisi in court requires none of the parties to attend or their solicitors. Decree nisi is the first decree on divorce. The couple are still married at that stage, but it means that the petitioner has jumped through all of the hoops and can obtain a divorce in the courts of England and Wales. 6 weeks and 1 day after pronouncement of decree nisi, the petitioner can apply for decree absolute, which dissolves the marriage and the parties are no longer husband and wife. I hope that this leaves you a little better informed about divorce procedure. The important points for you to remember are that you don't need to go to court, and if you and your husband or wife can cooperate, then the process will be quicker and smoother, it will be less stressful, and the costs will be less.